In 2006, the nation was captivated when three Duke University lacrosse players, David Evans, Collin Finnerty, and Reade Seligmann, were charged with rape. The uproar in Durham County, North Carolina, was divided along racial lines. The accuser, Crystal Mangum, a part-time student at North Carolina Central University who worked as a striptease dancer and prostitute, had accused the three Duke men's lacrosse players of rape at a fraternity party, igniting a national firestorm. What was later uncovered were several layers of professional misconduct by all facets of local law enforcement and Duke University, which saw lawsuits filed, criminal charges filed against other parties, and a sordid tale of lies, deceit, and professional corruption. But what was the real story? Who were the three accused students? What was the evidence against them? Why is this case controversial? What was the final outcome? Hello, I'm Colin Heaton, former history professor, Army and Marine Corps veteran, and welcome to this episode of Forgotten History. On March 13, 2006, the Duke University lacrosse team held a party at 610 North Buchanan Boulevard, and during the party, the two women, Crystal Mangum, who was black, and Kim Mara Roberts, also known as Kim Mara Pittman, a half-black, half-Asian woman, arrived separately as Roberts drove herself, arriving first, with Mangum later dropped off by her then-boyfriend. Mangum had already consumed alcohol and Flexeril. After a verbal altercation with one student, the women went to the bathroom, and players Seligmann and Finnerty had already left. When the women left the bathroom, Mangum began roaming around the yard half-dressed and shouting. This was the point at which Mangum later claimed that she was dragged into the bathroom and raped, beaten, and choked for half an hour. But the party broke up and people were asked to leave. Roberts and Mangum argued with each other as they drove to a nearby Kroger supermarket, and Roberts went inside and told a female security guard that a woman was refusing to leave her car. The female guard asked Mangum to leave the car, but she refused. At 1:22 a.m., the guard called 911 to report the situation. Then police arrived, removed Mangum from the car, and questioned her. The guard said she had not smelled alcohol on Mangum's breath, but thought that she might have been under the influence of other drugs. This was where the police were given the first statements by both Roberts and Mangum. Mangum had no identification and was very uncooperative. She was having difficulty walking, seeming impaired, and she was taken to Durham Center Access, a mental health and substance abuse facility for involuntary commitment. This was where she claimed that she had been raped at the house. Meanwhile, police arrived at the house, which was closed and locked as the party was over, and no one answered the door, so they left. Mangum was then transferred to Duke University Medical Center for examination of her skin, arms, and legs. The exam revealed no swelling, no abnormalities, and 3 small cuts on her right knee and right heel. When asked, she denied having been struck by anyone. The exam did show swelling of her vagina, and Mangum said that she had used a vibrator in a show for a couple in a hotel room before the lacrosse team party. No other injuries were in the medical report. The next day, on March 14th, the Durham Police Department began their investigation by interviewing Mangum and searching 610 North Buchanan pursuant to a warrant. The 3 team captains who lived at the house, including Evans, voluntarily gave statements and DNA samples, and they offered to take polygraphs, but the police refused their offer for some reason. What the police later claimed was major evidence was an email sent 2 hours after the party was over by team player Ryan McFadden to other players saying that he planned to have some strippers over, kill them, and cut off their skin. The email was considered a joke by all parties, if in bad taste. It was seen in the many responses and believed to be a parody of the book American Psycho, which had been studied in class. The police released the McFadden email to the public, but refused to release the following email exchanges to give full context, which proved it was a joke. This gave the public the impression that the email was intended as a serious threat. Afterward, McFadden received over 1,000 death threats in 1 week. The selective release of the email led many people to assume the players were guilty, thereby tainting potential jurors and influencing the Duke faculty. In fact, McFadden was never charged with any crime, but he was temporarily suspended, with the university citing safety concerns, but he was invited back to Duke later that summer. The DPD made their investigation public on March 15th when Sergeant Mark Gottlieb, the police supervisor, posted on a digital community bulletin board that they were investigating the rape of a young woman by 3 males at 16 North Buchanan on March 13th and asked anyone in the area who saw or heard anything unusual to contact investigator Benjamin Hyman. Mangum had difficulty choosing her attackers at first, as all the photos were only of the 46 lacrosse team members, violating police policy of including photos of people who were not suspects. The U.S. Department of Justice guidelines suggest including at least 5 non-suspect filler photos for each suspect to be included, as did the Durham Police Department's own General Order 4077, which was adopted in February of 2006. Initially, Mangum identified Seligmann being at the party but not as one of her attackers, and she never identified Evans at all despite seeing his photo twice. Later, changing her mind, Mangum identified photos of Seligmann, Evans, and Finnerty as her attackers. She also identified at least one other photo as being a player who was present at the party. Further investigations showed that student had not been there at all. Within a few hours of receiving the briefing from Gottlieb and Hyman on March 27th, Durham County District Attorney Mike Nifong, a Democrat running for public office, made his first public statement on the case. It was an election year, and he needed the black vote to stay in office or lose his job, so he played the race card. Over the following week, Nifong gave up to 70 interviews and more than 40 hours to reporters. After that, he continued to make statements, albeit less frequently. Nifong claimed the team members failed or refused to provide information to law enforcement. Nifong claimed the students were uncooperative and invoked their Fifth Amendment rights, but none of that happened. While campaigning, Nifong offered his own opinions that it was a racially motivated rape, stating that 1 or more lacrosse players were guilty. On April 10, 2006, Nifong was informed by the state crime lab that DNA testing did not detect any of the 46 team members to the crime. At the time, under North Carolina law, the crime lab did not have to release the results to defense attorneys, only to the DA. That was the fiduciary responsibility of the DA under the U.S. Constitution and state law to present that evidence to the defense. That law has since been changed as a result of this case. Nifong was grasping at straws. He then had the samples sent to a private laboratory, DNA Security Incorporated in Burlington, North Carolina, for another test, where he had a friend. DNA from multiple identified males had been found, but none matched any of the lacrosse players. Nifong received that report, but as the DSI director, Brian Meehan, later testified, Nifong asked him to deliberately withhold the exculpatory information exonerating the players from the lab's report, so Meehan submitted a false report, which is a crime. Despite the DNA proving none of the players were guilty, on April 18th, Seligmann and Finnerty were arrested and indicted on charges of first-degree forcible rape, first-degree sexual offense, and kidnapping. Search warrants were executed on their dorm rooms as well. But Seligmann had a solid alibi in the form of ATM records during a withdrawal captured by photographs at the machine, his cell phone records, and an affidavit from a taxi driver who drove him there.
Outside makeup, talking to the student, he said she just is stripper.
Nifong dismissed that evidence and gave more public announcements. On May 1, 2006, the New Black Panthers held a protest outside Duke University. Many were wearing knives on their belts. Before entering the campus, a leader of the protest said, "We are conducting an independent investigation and we intend to enter the campus and interview lacrosse players. We seek to ensure an adequate, strong, and vigorous prosecution." Nifong had created a storm as the case drew national attention and highlighted racial tensions within the Durham area, which he tried to use to his advantage. In 2006, Jesse Jackson promised that the Rainbow Push Coalition would pay the college tuition for Mangum and that the tuition offer would still be good even if she had fabricated the entire story. It was reported that Nifong had told his campaign manager that the case had provided him with millions of dollars in free advertising. Nifong's efforts to push the case in the black community saw him win the primary election on May 6, 2006, on the basis of strong support from the black community by a slim margin of 883 votes. As Nifong continued pushing the bogus case in public, he won the general election in November 2006, although by a lower margin than usual for Democrat candidates in Durham County. On May 15, 2006, after Mangum again changed her mind, Duke graduate Evans was also indicted on charges of first-degree forcible rape, sexual offense, and kidnapping. Just before turning himself in at the Durham County Detention Center, he publicly declared his innocence and his expectation of being cleared of the charges within weeks. But problems with the case were apparent, but Nifong buried those issues. Roberts, in her initial statement, has said she was with Mangum the entire evening except for a period of less than 5 minutes, and called the rape claims a crock, that there was no rape, but Nifong never informed the defense. Still confident he could make a case, Nifong ordered the remaining 46 of the 47 lacrosse team members to provide DNA samples, those who had not already done so, although some of those players were not even at the party. The sole black member of the team was exempt because Mangum claimed that all of her rapists were white. But Nifong's case was in even more serious trouble with questions arising about Mangum's credibility, such as her conflicting stories and Roberts' statement, and that if given to the defense it would destroy his case. None of this information was given to the defense, which is illegal. Durham police had again told Nifong that Mangum kept changing her story during her interviews, and she was not credible, reporting that she initially told them that she was raped by 20 white men, later reducing the number to 3. Another police report states that Mangum initially claimed that she was groped rather than raped, but changed her story before going to the hospital. On December 15, 2006, all 3 defense attorneys made a motion arguing that the DNA analysis report from DSI provided to them by Nifong's office was incomplete because it omitted any information regarding any DNA samples matching the lacrosse team. The defense lawyers requested to independently test the evidence. They also inquired as to whether or not Nifong had received a report from the state crime lab, which he never provided. Nifong was ordered to release the state report, which was redacted. The judge agreed with the defense, and the independent DNA results were later to reveal that Mangum had sex with several men who were not a Duke lacrosse player. Attorney Joseph Cheshire said the test results from the SI lab indicated DNA from a single male source came from a vaginal swab along with others. The media reported this DNA was from her boyfriend. The judge also ordered the interviews to be given to the defense. In the new version from the December 21, 2006 interview, Mangum claimed she was attacked from 11:35 p.m. to midnight, much earlier than her previous accusations. Seligmann's attorney also zeroed in on that December 21 interview, proving Mangum lied. The families of the 3 men were wealthy enough to hire their own private investigators, collaborating with the attorneys. Had this not been the case, the 3 men would have probably been convicted. It was proven that Seligmann was on the phone with his girlfriend during the height of the alleged attack. Additionally, Mangum received an incoming call at 11:36 p.m. that lasted for 3 minutes, which would have been during the supposed rape, which Roberts and phone records confirmed did not happen. It was proven that the 2 women stayed at the party for an hour after the supposed attack. Kim Roberts left with Mangum at 12:53 a.m., but in her April statement, Mangum said they left immediately after the attack, which was proven to be a lie. Mangum changed the name of her attackers, claiming they had used multiple pseudonyms. She also changed her description of Evans. She previously said that she was attacked by a man who looked like Evans with the addition of a mustache. Later, in a second interview, she said that the assailant had a 5 o'clock shadow and that Seligmann was there. Gottlieb, Hyman, and Nifong knew that she was lying. They knew the truth. In yet another account, Mangum claimed she was suspended in midair and was having sex, being assaulted by all three of them in the bathroom. Even the State Attorney General Roy Cooper said this event seemed very implausible because of the small size of the bathroom. According to a 60 Minutes investigation, Mangum gave at least a dozen different stories. The News and Observer paper, North Carolina's second largest newspaper, conducted its own investigation. It was determined that Mangum gave at least 5 different versions of the incident to police and medical interviewers by August 2006. It also surfaced that in the March lineup, Mangum did not choose Evans at all. During these 2 sessions, she identified only Brad Ross with 100% certainty as being at the party, but Ross proved he was not even there but with his girlfriend at North Carolina State University. The complete DNA findings came in and finally revealed during defense attorney Brad Bannon's testimony. Armed with a complete DNA report, unredacted, according to conservative estimates, the lab had discovered at least 2 unidentified males' DNA in Mangum's pubic region, at least 2 more unidentified male DNA in her rectum, at least 4 to 5 unidentified males' DNA on her underpants, and at least 1 more identified male's DNA in her vagina. None belonged to any of the accused men and had been deliberately withheld from the court and the defense by Nifong. It became clear that Mike Nifong did not submit any of the interviews or full DNA reports and withheld all the conflicting statements given by Mangum. This became even more clear, and he was accused by the defense attorneys of prosecutorial misconduct. Faced with the revelation of what would happen if a new test were conducted, and given his illegal activities, on December 22, 2006, Nifong dropped the rape charges against all 3 men. His excuse was that Mangum told investigators different versions of events, and he said she was no longer sure about some aspects of her original story. Nifong was saying he was dropping the case because his chief witness had no credibility. On December 28, 2006, the North Carolina Bar filed ethics charges against Nifong over his conduct in the case, accusing him of making public statements that were prejudicial to the administration of justice and heightened public condemnation of the accused, and of engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. The 17-page document also accused Nifong of violating 4 rules of professional conduct, listing more than 100 examples of statements he made to the media, as well as Brady violations for withholding exculpatory evidence. On January 12, 2007, Nifong sent a letter to North Carolina Attorney General Roy Cooper asking to be taken off the case. The following day, January 13th, Cooper announced that his office would take over the case. On January 24, 2007, the North Carolina Bar filed a second round of ethics charges against Nifong for a systematic abuse of prosecutorial discretion that was prejudicial to the administration of justice by his withheld DNA evidence to mislead the court. Initially, Roy Cooper, the North Carolina Attorney General, first disputed the report, but given the evidence collected by the defense team's private investigators and the material ordered released by the judge, on April 11, 2007, Cooper declared the accused players innocent of all charges. Cooper had known all along what was going on, and he was part of the corruption, because as Attorney General, he oversaw the state crime lab. Cooper then announced that Mangum would not be prosecuted, stating that investigators and attorneys who had interviewed her thought she may actually believe the many different stories that she has been telling. It's in the best interest of justice not to bring charges. Well, that was rubbish. This decision was political because Cooper, as a Democrat, also had to run for re-election, and he needed black votes. Cooper would eventually be elected governor later. The following corruption and misconduct by Nifong, Hyman, Gottlieb, and others was revealed, and it was shocking. Police used intimidation tactics on witnesses because on May 11th, Mozeldin El Mustafa, the immigrant taxi driver who signed a sworn statement about Seligmann's being with him that night, which provided the solid alibi and corroborated by the ATM machine, photos, taxi dispatch record, and bank transaction. However, he was still arrested on a 2.5-year-old misdemeanor shoplifting charge. The arresting officers asked him if he had anything new to say about the Lacrosse case. When he refused to alter his testimony, he was taken into custody. An arrest and conviction would have destroyed his chance for citizenship, and he could have been deported. Al-Mustafa was subsequently tried on the shoplifting charge and acquitted after a grainy security tape proved that a security guard who was the prosecution's chief witness had misremembered events, and it was chalked up to simple misidentification. Police also arrested Mangum's former husband, Kenneth McNeil, her boyfriend, Matthew Murchison, and another friend to try to coerce them to assist with the case. They all had criminal cases with DA Michael Nifong. Sergeant Mark Gottlieb had a history of targeting Duke students in the past in a clear abuse of authority. Charges against Gottlieb included warrantless searches, abuse of power, making threats, and perjury under oath in several previous court cases. Nifong's chief investigator, Linwood E. Wilson, also had a troubled record with honesty, and he was censured a few times. On June 25, 2007, interim DA Jim Hardin Jr. fired Wilson from his post. But what was the fallout from this case? Well, Mike Pressler, the coach of the lacrosse team, received threatening emails, hate calls, and slanderous signs placed on his property, and his property was frequently vandalized after the accusation surfaced. On April 5, 2006, he was forced to resign after the McFadden email became public.
Since former Duke lacrosse coach Mike Pressler was forced to resign amid allegations some of his players raped an exotic dancer.
Through his lawyer, he stated that his resignation was not an admission of wrongdoing on his part. On the same day, Richard H. Broadhead, president of Duke University, suspended the remainder of the lacrosse season. Other Duke faculty members were later criticized for their social disaster letter, as well as individuals commenting on the case and reactions which created a perception of prejudgment. Also, photographs of lacrosse team members had been posted around Durham and on the Duke University campus presuming guilt. The liberal media nationwide also supported the prosecution theory without any tangible evidence. TV presenter and former Atlanta DA Nancy Grace publicly supported the prosecution case, further tainting a jury pool.
It's going to be on a jury now. That's right, indictments handed down, arrests made on at least 2 young men.
Fox News was the only national television news outlet to reveal Mangum's photo following the dismissal of the case, although MSNBC and 60 Minutes revealed her name. Several major broadcasters did not publish Mangum's photo or name at any point, including ABC, PBS, CNN, and NBC. However, during the almost year-long case, these same liberal media outlets always presented photos and video of the 3 accused men, always mentioning the charges. But following the acquittal, all of that disappeared, and there were no apologies. On June 16, 2007, the North Carolina State Bar ordered Nifong disbarred after the bar's 3 unanimously found him guilty of fraud, dishonesty, deceit, or misrepresentation, of making false statements of material facts before a judge, of making false statements of material fact before bar investigators, and of lying about withholding exculpatory DNA evidence. On June 18th, Durham Superior Court Judge Orlando Hudson ordered Nifong be immediately removed from office. On October 31, 2007, Nifong was held in criminal contempt of court for knowingly making false statements to the court during the criminal proceedings. Durham Superior Court Judge W. Osmond Smith III sentenced Nifong to only 1 day in jail. But what happened to the accused students? All 3 students brought a civil lawsuit against Duke University, which was settled with the university supposedly paying approximately $20 million to each man, but Seligmann's attorney told the New York Daily News that the settlement was nowhere near that much money. The students also sought further unspecified damages and called for criminal justice reform laws in a federal civil rights lawsuit filed against the city of Durham and its police department. In May 2008, Crystal Mangum graduated from North Carolina Central University with a degree in police psychology, and she authored a book, The Last Dance for Grace, The Crystal Mangum Story. In it, she continued to contend that she had been raped at the party and that the dropping of the case was politically motivated. Mangum was found guilty of second-degree murder in November 2013 after she stabbed her boyfriend, Reginald Day, who died 10 days afterward. She argued that she acted in self-defense, fearing that Day would kill her. She was sentenced to 14 to 18 years in prison. During a December 11, 2024 podcast interview, Crystal Mangum admitted that she made up a story that wasn't true about the white lacrosse players who attended a party where she was hired to be a stripper and wanted to apologize for her actions publicly. As for the students, Seligmann enrolled at Brown University in the fall of 2007 and helped Brown reach the 2009 NCAA lacrosse tournament, as well as a number 10 national ranking. He became an active fundraiser and supporter for the Innocence Project and graduated from Brown in 2010 and then graduated from Emory University School of Law in 2013. He said that his experience during the case motivated him to attend law school and pursue a legal career. Finnerty graduated from Loyola College in Maryland in May 2010. Evans, who had already graduated from Duke before being charged, received an MBA from the Wharton School of Business at the University of Pennsylvania in May 2012. Duke's athletic director, Joe Aleva, who forced lacrosse coach Mike Pressler's resignation, faced severe criticism for his handling of this case. In 2008, Aleva announced he was leaving Duke for the athletic director position at Louisiana State University. Coach Mike Pressler and Duke reached an undisclosed financial settlement in 2010. On January 15, 2008, the city of Durham filed a motion to be removed as a defendant, arguing that the city had no responsibility for Nifong's actions, and the same day, Nifong filed for bankruptcy. On May 27, 2008, Judge William L. Stocks lifted the stay from Nifong's bankruptcy filing and ruled that the plaintiff's lawsuit could go forward. Duke offered to cover the cost of any attorney's fees or other expenses, but the students rejected this offer. The city never released an official response to the lawsuit. The lawsuit against Duke University was settled out of court on May 16, 2014. Neither side would discuss the details of the settlement. In July 2014, Sergeant Mark Gottlieb, who had lost his job as a police officer in Durham due to his participation in the cover-up, took his own life in DeKalb County, Georgia, where he had worked as a paramedic. Finally, Crystal Mangum did the interview on December 14, 2024 at the North Carolina Correctional Institution for Women, where she said, "I testified falsely against them by saying that they raped me when they didn't, and that was wrong, and I betrayed the trust of a lot of other people who believed in me," she said on the web show Let's Talk with Kat, hosted by Katerina de Pasquale. Mangum stated also, "I made up a story that wasn't true because I wanted validation from people and not from God. I want them to know that I love them and they didn't deserve that, and I hope that they can forgive me." Basically, when politics and law come together, there will always be the threat of corruption. Thank you for watching this episode of Forgotten History. If you liked what you saw, please click like, share, and subscribe. And if you would like to assist with the ever-increasing cost of production, please consider becoming a channel member and joining our Patreon page. Please check out our merchandise store. And thanks for watching.